So good afternoon, everyone, and welcome to today's webinar, Navigating Compliance in 2025, Key Updates to the Fair Work Act and Payroll Risks. I'm Colin McGrath, a Director at CXE, and I'll be your host. So as we head into 2025, businesses across Australia are facing increasing scrutiny around payroll compliance, superannuation obligations, and contractor workforce risks. These challenges impact industries across the board, from universities and healthcare to retail and energy, all of which are represented in today's audience, along with other sectors. So we've seen major universities under the spotlight for wage compliance issues, but they're not alone. Every sector that engages contractors, flexible workers, and manages payroll tax obligations is under increasing pressure to stay compliant while maintaining workforce flexibility. So how do organizations navigate these risks while staying compliant? Well, that's exactly what we'll be unpacking today. And I'm delighted to say we're joined by two of Australia's leading experts in payroll compliance and workplace law, who will break down the biggest risks, key legislative changes, and practical steps you can take to stay ahead. So without further ado, I'll hand it over to the speakers. Maybe Rowan, you can kick off.
Thanks, Colin. It's great to be here. So my name is Rowan Geddes. I'm the partner that leads the payroll and advisory practice at PwC as part of our workforce team. We do a lot of work in relation to supporting organisations get the best out of their payroll functions from an efficiency perspective, and also a lot of work around wage remediations. Thanks, Colin.
No worries. And Nick?
Thanks, Colin. If I can just begin by saying best wishes to you and everyone else who's in southern Queensland and northern New South Wales at the moment. The rest of Australia is certainly thinking of you. My name's Nick Dougal, and I have the privilege of being the National Practice Group Leader at the law firm Moray and Agnew. And in that capacity, one of my core areas of expertise is labour hire or contingent labour arrangements, which have been subject to a lot of change recently with the legislative changes that we've seen.
Great, and thanks for that, Nick. So I just want to say it's going to be an interactive session today, or we hope it will be. So feel free to drop your questions in the chat at any time. Ella from marketing team will keep an eye out and shout at us to let us know there's some questions in there. And if we don't get to your question during the session, we're happy to stay on for an extra 15 minutes or so to cover anything outstanding. So let's get started. Okay, so maybe Nick, to start with, businesses are facing growing pressure around compliance, whether it's payroll tax, superannuation, or ensuring correct payments to workers. From your recent conversations with clients, what's keeping organizations up at night right now?
Colin, from my perspective, the biggest thing to come out of the recent legislative changes is the uncertainty around the definition of an independent contractor and the definition of a casual employee. It's really difficult for businesses now to be able to have any confidence whether, if it's subject to a test, whether a court or commission's going to agree with them that it's right to label that worker an independent contractor or a casual employee. So the compliance challenge for businesses coming out of that is to de-risk that uncertainty through the contractual materials. So we've been putting a lot of work in with clients to ensure that their contractual materials align with the legislative changes and essentially de-risk underpayment risk should that worker be found to be any other form of worker other than what they've been labelled.
Right. And what about yourself, Rowan?
Yeah, probably building on from Nick's point, taking up to the payroll level. I think the biggest thing on the payroll side at the moment, with all the change going through, is the criminalisation of wage theft. And that's not so much around, am I going to go to jail, but the impact of that onto organisations around the processes that they're putting in and the governance they're putting in around their payroll, because there's an increased expectation that businesses will put the right level of support around that. And then I think the other two that's coming through, long service leave, is something that we're seeing more and more activity on. for employers. And then there's been conversation about payday super. And not so much about that because payday super is not legislated yet, so we're still waiting to see the detail. But it shows again the tax officers move around capturing digital information and being a lot more proactive and more targeted around what they're looking at. And then payday super is opening up opportunities in the future for superannuation compliance. So we're watching that space too.
Okay, and in that area, superannuation compliance, I know we've spoken about sole traders previously. What should business considering when looking at the sole traders?
So look, I think the starting point for sole traders is that if you're engaging a contractor as a sole trader, you need to recognise that you've automatically increased your risk of employment obligations being attached to them, because Nick talked about some of that confusion that's come back into the system around contractor versus employee. Certainly, if you're engaging somebody as a sole trader rather than through an interposed entity or through an organisation like CXC, you run a much greater risk of them being viewed as an employee and then being liable to superannuation. The other superannuation thing that we've seen coming through is what's called the entertainer provision. And that is that if you're an entertainer, then you have a superannuation obligation. Now, why is that relevant to most employers? Entertainers are anybody that's involved in the creation of content, which brings you into things like social media, which brings you into the things like your if you bring people in to do videos and things like that. It's a much broader list than the entertainers that maybe you and I would think about when we think about entertainers. So there is a lot more focus into that area. And as I said, with things like payday super and a lot of the STP2 changes that came through a couple of years ago, there's a lot more information that the tax office has to hand that they're now able to look at and target when they're doing review programs.
Right. Do you have anything to add on to that, Nick?
Yeah, look, engaging independent contractors as sole traders is increasingly a risky proposition for a variety of reasons. What we're seeing, which sort of compounds that risk, is that in encouraging clients to not have sole trader independent contractors and in the alternative engage their independent contractors via their contractor services company, the contractors who are unwilling to do that tend to be the lesser sophisticated and working in, jobs which are more closely akin to those jobs that might be covered by, say, modern awards or, clerical or office duties and things like that, contract cleaning. And those sorts of duties and that sort of pay grade for a worker makes it even more likely at law that they're going to be found to be an employee. So the clients I've been working with are really down to the bare bones of who they've got as sole trader contractors. It's been managed more as a legacy issue rather than anything else. And it really comes down to the commercial consideration of, it's either have that worker as a sole trader or don't have that worker at all. And then the next questions are as well, do they have an ABN, which from our perspective is essential. And as Rowan says, what do you do with superannuation contributions, and also how is that as reflected as best possible in the terms of engagement?
Right. Look, as I mentioned, there's a lot of sectors that's registered to this webinar, but in particular, probably the universities and the healthcare has been represented in particular the most. Do you have any specifics in terms of those industries that you'd like to talk about and, what's happened and where you think it's going to go?
Ron, I'm happy to take that one first.
Start? Yeah.
Look, I do a lot of work in health and education, and I think one of the significant risks for contingent labour in those sectors is that you are dealing with blended workforces. So you've got casual employees working alongside contractors, working beside permanent employees. And sometimes it's hard to distinguish substantively the differences in what they are doing. Now, that can create risk in relation to a court or commission or regulator being persuaded of, well, they're just tantamount to permanent workers. It also creates new risks around same job, same pay applications that we're beginning to see coming through from contingent workers asking for the same terms and conditions as EBAs covering direct employees. And also, the other point I would make for universities and employers in the health sector is sometimes they're not really across the composition of their own workforce because the workforces are very large. They might not know how many contractors they actually have. They might not know who's engaging those contractors. Sometimes you have different departments engaging contractors directly, for example, to avoid an increase in permanent workforce headcount. And that broad oversight is lost. And then, I have clients coming to me and saying, oh, we've had that contractor on our books for 8 years. Do you think there's a risk in that? We only just realised. So to me, there's some of the risks that I see arise quite a bit in those industries. And I think one of the first solutions is to really audit and work with a professional service provider to get across all the workers you have across all of those different strands.
Great.
Rowan, I'm sure you've got some additional thoughts.
Yeah, I think my favourite contractor versus employee was the contractor that was awarded Employee of the Month. It's going to make it hard to argue a contractor. I think the same job, same pay thing is interesting. There is in the current environment, there is a real shift from the government via the regulators to protect workers' rights. And we're seeing with same job, same pay, and the impact that's having on labour hire. From a contractor perspective, there's a perception that if you're a contractor, you don't have the same obligations, and we need to do stuff to protect that, which is where some of the changes came through around facts and circumstances tests for a contractor as to whether they're an employee or not. And that's flowing through all the different authorities, whether it be the tax office, Fair Work Ombudsman, or the state authorities as well. So what does that mean? It doesn't mean don't use contractors. What it means is to be rigorous in relation to how you engage with them and also how you use them over a period of time. If you've got a contractor that's been doing the same job for 8 years, they may not be a contractor anymore, even though that was the intention that's come through. And what has happened as part of the legislation is the fact that the legislative change is the fact that you engage somebody as a contractor under a contract that says they're a contractor that they sign. If the circumstances change over time, then they may not be they may not be a contractor going forward. So you do need to be rigorous around how that applies to come through.
Right. Did we have a question come through? I just saw. So thanks, Linda, for sending through a question. So project type work can be a bit of grey when it comes to contractors. The master-servant relationship is key to assessing the type of engagement. So is the master-servant relationship key to assessing the type of engagement?
A master-servant relationship by historical definition is an employment relationship. So I would avoid using that expression if you're hoping to engage someone as a contractor. Project work, if constructed effectively in the contractual materials, can be a good basis to say that someone's a true contractor. And some of the reasons for that are that they would need to be bringing their own expertise to that contract. So you're engaging someone who can supply a service autonomously, and that engagement is not ongoing in nature. It's for a specific project. So if you draft it to say, you're to supply this expertise, consultancy service or whatever, it's on this project for this client. And, projects, the time periods of projects can change, and some projects can be very long. But if it's from beginning to end on a particular project, on a project that is going to end, that can be good grounds to say that someone's a true contractor, I think.
Nick, there's some developments as well from a project basis around the length of fixed term contracts.
Yeah.
And I think that starts to fit in some of this too. So under the changes that came through 18 months ago now, you can no longer engage an employee or a worker on an employee because it's part-time on a fixed term contract that goes for more than 2 years in total. So if you've got, and there's some exceptions, so if they come in on a parental leave basis, you can get exceptions through that. But on the idea of bringing people in and engaging them on a fixed term contract and then rolling that contract over and over and over, you can't do that anymore. You've now got a 2-year limited time in which that would apply. After that time, you've got to make the employee a permanent employee to work through. So again, is that piece around permanent? Is that piece around protecting workers' rights?
Yeah. So, and to just pick up on one thing that Rowan said about that, within that 2-year time frame is any renewals. So it's not like you can engage a worker for 18 months and then renew that engagement for another 12 months and not be caught by that 2-year limitation. I think for a project, if you're getting to that kind of 2-year time frame, and I do understand that some projects are quite long, but if you are looking to engage someone for a specific project for over 2 years, you are maybe crossing the boundaries of the feature of that being a project being decisive in that worker not being found to be an employee at law.
It is something we haven't seen tested a lot at the moment. It's still going through, waiting to see it go through the Fair Work Commission. So I think it's a bit of a watch this space at the moment. So
yeah, look, I think a lot of it is we haven't seen test cases for the new definition of casual. We haven't really seen many test cases over casual conversion. So to me, a lot of the heavy lifting went into preparation for these laws. But what has come out in terms of decisions, it's still a bit of a wait and see.
Right. I can see, Jane, you've asked a question here. So for fixed term contracts, aren't there exemptions for universities for externally funded research work? Are you anticipating this might change?
Yeah, there are some exemptions. Ironically, there's exemptions for contracting to government. So yeah, there is a couple of exemptions where you're limited to the terms of the grant has been provided to you. So no, not seeing changes pending on this. I mean, who knows what's coming through? But I think as Nick said, we're still waiting to see how this is applying, going through and being tested. I think even the President of the Fair Work Commission has talked about the need to get test cases up for some of this stuff to really understand what it means.
Yeah,
so maybe. Sorry.
I was just going to say 2 exceptions that we have found useful as those in relation to earning over the high income threshold, and also where a position is reliant on government funding, in particular in health. We've found that quite helpful, and the same would apply to universities.
Okay, I may be following on for that. It's more a broad question. With a change in government, do you anticipate any changes? Or is it too hard to tell, or is there anything on the horizon?
I'll do that. Look, there's absolutely been a shift under the current government with a focus on that. I think that a change of government raises the possibility of some of that pulling back. It's not going to pull back to what it was 4 years ago. I think we've given rights to workers. You're not going to take them away. So, but we have seen a slowdown in relation to legislative change in the last 12 months, which is welcome, because there was a lot that went through between closing loopholes and secure jobs bill. So I think there'll be a settling there, but we haven't seen the policies yet for the new government, for either government, in relation to what they're going to do in the next term. So,
okay,
yeah, I would just add to that by saying, and when federal governments change, the incoming government tends to want to do something about industrial relations, because that's the big football between the major parties. But in this electoral cycle, we haven't seen the opposition carve that out in stone for the purposes of the election campaign. So I would assume that over the duration of a term, and they would want to be in for longer the term. So ultimately they will have designs to do something, but it doesn't sound like it's going to be the first port of call on their agenda. Unless you're a public servant working from home, you might you might find that your arrangements are under scrutiny a little bit earlier than that.
Yeah. Right. Okay. I'm just checking. I don't think there was more commentary than a question. Maybe I'll jump into when using suppliers, labour hire companies, consultancies using an SOW model. What are the risks involved in that? What's the protections involved in that? How does that look? Throw it to you. Maybe you're going first.
I think one of the advantages of using interposed labour hire companies and suppliers on that is that you've got people that are doing this all the time. And so they're seeing what's best practice to work through. So I think there's a value that comes through from there. The same job, same pay that's been a focus onto labour hire from there. That's really aimed at a specific type of concern, which is that if you've got an organisation that has their own enterprise agreement that covers all of their employees, the concern is that some employers will engage labour hire contractors that aren't covered by that enterprise agreement, and will end up with less employee favourable positions to come through. And so the concept of same job, same pay is that if you're doing the same job, you get the same entitlements as what would happen to the end employer. So, Colin, I think it goes to what's the purpose of engaging the labour hire company to come through. The benefits of it to me sit with that management of risk that comes through, and management risk coming, as I said, from the fact that the labour hire company will see a lot more of those edge cases and know how to deal with those pieces too.
Okay. Do you have anything, Nick, to add?
Yeah, I'd probably go a step further in relation to the utility of a labour hire provider. And Rowan, sorry to remind CFC of this, but if you use a labour hire provider, you are pushing the contractual relationship onto the labour hire provider. So if anyone at law is found to be the employer, then it's the labour hire provider, not a third party that doesn't have a direct contractual relationship with the worker. So from a legal perspective, it's very useful in removing yourself from the contractual working relationship. The other thing I would add is, I think part of that question was a reference to the term statement of work, which is a term bandied about in the industry. If you are engaging a worker directly via a statement of work document, it's important to remember that is a label that doesn't have a lot of legal recognition. So a judge or a regulator is not going to look at that and say, okay, that arrangement's called a statement of work, nothing to see here. That they will look into the substance of that relationship and assess whether in all of its parts and holistically whether it looks like an employment relationship. And I've certainly seen working arrangements labelled as statement of work, but when you actually peel the onion and look at what the worker's doing, the risk is still high that they could be found to be an employee at law.
Right. Well, we got a question here, a bit more specific. I'd like to hear more around universities who are dealing with casual long service leave and obligations.
So that's a state by state issue. So long service leave legislation differs, but sometimes in some state, it's just a cold fact that if they have been casually employed by you for a period that qualifies for long service leave, that they're entitled to long service leave. So, I mean, what I would be suggesting is that long before workers accrue a potential entitlement to long service leave, that the effectiveness of continuing on with that relationship as a casual employment relationship be considered. Now, the other thing I've been exposed to quite a lot is where it's in the context of a labour hire relationship. So it's very important for the parties to come together before that long service leave liability ticks over and come to a commercial arrangement about what they're going to do, because that will blow out the margin for the labour hire provider. And if everyone wants the labour to continue, including in that form and including the worker, which often they do, often workers don't want to be moved off casual working relationships. For example, they don't want to lose their loading, but everyone should be able to come to an accord before the long service leave ticks over. So it's another important reason as to why large employers like universities need to be well across the composition of their workforce.
Okay.
We're doing quite a lot of work at the moment for retail in relation to long service leave and casuals. And it is, look, the biggest complexity on it's going to be the maintenance of records that has come through over long periods of time. And the problem is with long service leave that what starts, when you start looking at it now, you're going back 10, 20 years worth of information. So it is an absolute challenge from there. And yeah, universities would be affected by that too. Colin, this is poor form, but I can't resist this. I'm just going to call out that next week we're hosting a webinar ourselves with the Wage Inspectorate of Victoria and Deputy Commissioner for New South Wales Industrial Relations about long service leave. So if you're interested too, you jump on my LinkedIn profile and there's a registration there. I'm really sorry to plug my own thing, but timing was perfect.
No, great. And I've just seen quite a few more questions coming in. So with the casual closing loopholes legislation implemented as of 26th of August 24, do employers need to issue a contract of employment and offer of work separately to ensure there is no firm advance commitments of work? Does anyone want to take that one?
So I'm just trying to work into the question. So the issue from a casual's perspective has been that the question around whether a casual is casual or permanent. And there's been changes that have made to make it easier for a casual to request a conversion to become a permanent employee to come through. They can now do it on a regular basis throughout the terms of their engagement. And the sort of factors that will come through will be if you have a regular expectation of work and a fixed pattern of work that's going through. So someone's working 3 days a week for a 6 month, 12-month period. They then have the right to request to be viewed as a permanent. And if they do make that request, employers need to tell them they've got that right. And if they do request to be converted to permanent, then the employer has to explain, if they say no, they've got to explain why not, and what's the business reason for doing that. it creates an opportunity for the casual to take the matter to the Fair Work Commission to argue that they should be converted to permanent. Go back to something Nick said though. Not a lot of casuals want to become permanent. One of the first things that happens there is you lose your 25% loading. So it's something that they've had this casual conversion law in for a while now, under two versions of it, but it hasn't had the take up that I think the government or the unions thought was going to happen, because there is a flexibility that comes for casuals as well. What you do need from a processes perspective is you need to be able to identify what your casuals are doing in relation to roster patterns and hours. You need to be disciplined in relation to the communication with the casual employees around what their entitlements are, filling out the Fair Work Commission statements, those sort of things.
Okay, great.
Yeah, just a couple of things I'd add to that is, so we've moved from a situation where casual conversion was governed by modern awards, and that was a bit of a patchwork situation, depended on whether you were covered by a modern award, or it depended on whether that modern award had casual conversion provisions. The difficult thing for those who were covered by that old system is there were proactive measures that employers needed to take at certain junctures to tell employees that they have the right to seek conversion. So we don't have that patchwork system anymore. We've just got a general right of conversion for all casuals. Casuals do need to be issued with an information statement, but after that, they don't have to be reminded to apply to convert, but there's certain anniversaries that they can seek that. Now we're seeing, as Rowan said, and I think in particular in labour hire, where workers tend to have some impression of the contingent nature of their engagements, we're seeing take up of conversion as being very low, predominantly, I think, because of the loss of the loading. But what is important from our perspective is the one thing that employers don't want to be at risk of is if a worker is substantively found to be working akin to a permanent employee, that doesn't trigger a back pay claim. So, for example, annual leave and things like that. And your prospects of being able to avoid such a claim are very much improved by the drafting of the contract to provision for these new legislative changes. So that's one of the things that we've been working to protect employers against, and then keeping an eye out on any applications for casual conversion which have been live.
Okay. So, similar to the question above, universities are struggling with eligibility for long service leave for casual staff. It's confusing in the long service leave was granted by statute in 2006, but advice from Fair Work Ombudsman website, the website Modern Award Prevails, which is in effect on cancelling the entitlement for long service leave for casual staff until 2024. Would you please talk about the interaction of state law and federal law?
It's a really technical question. The state law tends to be where long service leave is determined, but yes, you can have federal law that steps into it, and then what it can come down to is, well, what provision leaves the worker better off? If it's the enhanced federal law, then sometimes, even if that federal law entitles someone to long service leave at a later date, it can still cover the field. But it's you really need to get into the nitty gritty of which federal industrial instrument you're talking about and which state-based legislation. So something like that does need to be the subject of specific advice.
Okay. Another one here, which is, can you confirm continuity of service covers any type of employment status, including casual, fixed term, and continuous?
Casual, fixed term, and contingent?
Continuous.
So continuity of service would cover.
Continuity of service covers any type of employment status, including casual, fixed term, and continuous.
Yeah. So yes to casual and fixed term. Casual, fixed term, permanent. Contingent contractors would be different from that.
Right.
Yeah. My short answer to that would be no. There's not a presumption of continuity of service, but there certainly can be deemed continuity or explicit continuity, including by virtue of the transmission of business provisions of the Fair Work Act, or what the parties agree at the time the relationship converts from one to another. For example, casual to permanent, or, transferring from a labour hire worker to a direct employee.
Okay. So maybe actually just shifting gears a little bit, Nick, I've seen you on Challenge 7 talking a bit about another emerging challenge, which is the growing demand for flexible and remote work arrangements, including short-term overseas remote work. So how are businesses approaching this, and what are some of the legal and compliance challenges they need to be aware of?
Yeah, well, thank you for that plug, Rowan. I am seeing increasingly workers who have been based in Australia who have resolved to return to a country of origin for an indeterminate period of time, but continue the working relationship. I saw it a lot actually. It began for me a lot during the pandemic, when workers wanted to return home to their families overseas, but they wanted to continue the working relationship. One of the big issues for me out of that was work cover, because you lose any capacity to regulate the safety of the workplace. So that one of the first suggestions we always had is, well, have you spoken to your work cover insurer about that? And what steps are you taking to ensure they've got a safe workplace? When we began to give this advice, it was in the context of the pandemic, where people were returning to countries that had very high rates of COVID. So that's one issue. Another issue that I'd encourage companies to think about is, in what country do you then want to have the work? Do you want the work arrangement to have jurisdiction? Because if the work is no longer in Australia and there's no indication of whether if or when they're going to be returning to Australia, is there a prospect of having a work arrangement that's governed by the laws of another country, in particular another country that doesn't have labour laws as prescriptive as ours? So that is another important thing to think about. But there's other implications for that. You're probably not going to be able to continue to pay them in Australian dollars into an Australian bank account and things like that. So I think those basic questions are important to answer, but we have been able to enable working arrangements to continue with essentially the same supply of service or labour, even though a worker has moved abroad for an indeterminate period of time.
And I can give a personal example of that. We had an employee during the pandemic move back to Estonia, and she then fell pregnant. And the question that we had was, well, what parental leave rules apply? Because she was an Australian employee working out of Estonia. We've also seen that with long service leave, and the fact that you're leaving the jurisdiction of New South Wales doesn't necessarily mean that the long service leave entitlement ceases. There's been a few cases around that, more inbound than outbound, but looking at that length of service and what that would apply, and that would be the same with termination and redundancy rules, and what the jurisdiction is from there too. So it is something that is a bit of a minefield around the complexity of it.
Yeah, and access to dismissal claims. I'm currently looking at that at the moment for a worker who's based in Thailand.
Yeah, I can see Ken Dwyer also mentioned here there may also be social security obligations for the hosting country that need to be considered. Yeah. Cool. Taking a step back again, I see there's a question, probably a follow-on from one of the earlier questions was, is there a consideration that unis hiring contractors through employment agencies to cover the work where they used to hire fixed-term staff? So basically, the loophole for unis. So I think if you're using the work you used to do as fixed term, now you're using a employment agent or labor hire company, I suppose. Maybe my understanding is what's your commentary around that, around being a loophole?
Get nervous the minute you use the word loophole.
I think it's correct me if we're wrong. I think the correct, from what you said, Nick, the contractual obligations basically sit with the labor hire companies. How down with the worker, but in saying that, you mentioned things like long service leave and stuff need to be worked on together. In kind of a joint response, as far as I understand it, Nick.
Yeah, if you're talking about the limitation on fixed term contracts. One thing I'd say about that is that I have worked with labour hire companies in relation to the prospect of the fact that they only have a contract with their client for a specific period of time. They can't guarantee work after that, and that being a basis for the exception for the 2-year rule. So that can be something that can be looked at in relation to those sorts of matters.
Right. Yeah, that probably better answers your question. Thanks for that. So I'm conscious we're coming up to the time. Does anyone else have any questions? Or Nick and Rowan, if you have anything you'd like to add or any of these areas? Is there any tips for some of the HR or payroll people on the call that you'd be willing to share?
Yeah, look, from my perspective, Colin, one thing that I haven't mentioned today, which has also been interesting, is the right to disconnect, in particular for multinationals.
Yeah.
So where employees based in Australia, as part of their role, need to be communicating with head offices or multinational clients, including within the business hours of people in other time zones, and how you align that to the right to disconnect and codify what is reasonable in the circumstances. I think that's another thing arising from the legislative changes. But the main tips that I would go back to are having a good macro oversight of the composition of your workforce and having the contractual materials to match, such that you're well structured to then being able to monitor that workforce on an ongoing basis. I'm conscious that we're coming up to time, but if anyone would like to continue that discussion after hours, very happy to speak to anyone on the call.
We got a few more questions. Can you stay on for, I think there's 3 more coming through. Are you happy to stay on, Nick and Rowan?
Sure.
Maybe Ella, I forgot to mention, can you flick back to the initial slide? So we've got a risk report with a code that you should be able to download if you're interested. Here. So feel free to scan that. So the questions that have come through are, would you like more information on I would like more information on casual long service leave in Queensland.
That's a pretty general question.
Yeah.
Yeah, I'd probably want more information on the specifics, and then I'd probably want to have that Queensland long service leave legislation in front of me.
Good. Okay. We got a comment that unis can hire through agencies to ignore any rules, I think, as a little bit of a joke. That's not the question. Then back to the definition of independent contractor. What more details would you like to share how to de-risk via your commercial arrangements?
There was there used to be a saying, looks like an employee, sounds like an employee, it's going to be an employee. And so I think we do need to consider the facts and circumstances of the way that you're engaging with your contractors. Contractors have a role to play, but they shouldn't be a substitute for a permanent workforce. And if you're using them as that, then you need to reassess the reasons as to why you're engaging your contractors to come through. If it's for project-based work, if it's for specialised opportunities, then you know, that makes sense. If you can't tell the difference between your employee and your contractor, then you probably got to have to reassess what you're doing with them at that stage. The importance of the contract, even though the facts and circumstances are relevant and ongoing, the importance of the contract can't be understated as a starting point. And so, knowing, engaging with the contractor, and this is when you're not going through a labour hire organisation. The engaging with the contractor as to what you're doing with them and why you're doing it, I think becomes and documenting that into a well-worded contract becomes important, because you will work back to that, as well as looking at what actually they're doing for their job going forward.
Right. I think that's covered all the questions, and I don't hope I've missed any. If I have, apologies. Look, unless anyone has any follow last questions or any commentary from Nick and Rowan, I think we can close up. So I just want to thank you everyone for joining the call today. We'll follow up with some more information, some ebooks around this, and feel free to reach out to us if you have any questions.
Thank you very much, Colin.
Thanks, Colin.
Thanks, Nick. Thanks, Rowan. And thanks, everyone, for attending.